Oh, let's see. Hold on here. Facebook seems to be having a problem. Hmm. All right. Good evening, folks. Welcome to Friday Night Fun Night. At least on YouTube. Facebook is looks like it's having a weird issue connecting. Let's see if it with a refresh. It says connecting live. So technical difficulties over on Facebook. Let's see. Right on, Lee. Thanks, brother. We're going to for sure. Any video over there on Facebook? It's showing here connecting live video to me. If you're on Facebook there, give me a heads up. Hmm. Seems to be working just fine over here on YouTube, just not Facebook. At least from my end. Guess I could try and look on my own phone here.
Wait until you turn around.
Anybody? Anybody? Not seeing any comments on Facebook either. Oh, two of them. Diesel D's. Diesel D's and Rocco. Good old fun times. No. Well, dang it. Okay. Facebook has definitely got issues. Let's see if I can get this. Let's restart one. Let's see if that'll work. All right, let's see. Bear with me, folks. Good old technical difficulties. There we go. How about that? All right. Good evening, folks. Welcome to Kirk's Law Corner Friday night fun night over on Facebook. Everybody else over here on YouTube's already been here for a little bit. I don't know, some weird stuff over on Facebook, of course. Always got to be something. You know, anybody catch the thing out of Canada there? Last name King case over there about, the thing that we can't talk about. Anybody else see that? I happened to get a hold of the paperwork, or at least most of it. Seems they're having a hard time proving that this thing exists. Wonder what's going on there. Be seeing what's going on here shortly when I file my paperwork. Because see, it's my turn. I have a couple of rights to a cause of action here, so I'm going to be doing something similar. I'm going to be demanding some proof. We'll see what happens here. Uh-oh. Prove it. Exactly. It's time to step up to the plate, people, and prove this shmew. Or prove that it's not shmew. Me too. I've been calling this crap out since it started. So, yeah, that's quite interesting how it's a simple demand for proof, and they just can't seem to provide that evidence or make any kind of a statement or what's going on there. Hey Kenneth, how you doing, brother? Mark, how you doing? Karen, Jacqueline, Dawn. Let's see who else is on here. James, Ginger. I do shout out to Tony Pellegrino today. His birthday is today, or his day of creation is what I call it. So over here on Facebook, let's see, we got Julie's on here. Hello, Julie. Let's go to the top here. I wonder if Diesel D's made it back. Billy Elson, Dorothy, Darren, Sylvia. Where's Kelly? You're on here. How you doing? Jason. Hello, Trisha. Well, we've had a little bit of a cool down here in Idaho, getting some thunderstorms and some rain over here. So it's kind of been nice the last day and a half. It still was a little bit warm the day before, but we went from 105 for the high on what was it, Wednesday, down to about it was still hit about 100 yesterday, and then today I'm not sure what we hit today. It wasn't too hot today. It was actually pretty nice. A little overcasty, a little bit of wind, rain this morning at about 4 a.m. Yeah, where are you at, Doug? Where's Cece at from Alaska? Where's Amber? Where you at, Amber? Oh man, lots of crazy stuff going on out there, right? Aside from the weather, and if you're in the southern part of America here, We got word of 115 down there. Holy smokes. So a quick shout out to all the team behind the scenes and the team at work here at the office. Having some pretty good discussions here with what we're putting together for the school. So things are coming together on that. There's Doug. We got to get out and hose his goats down. Is it warm down there, bro? I don't know the exact date, but there's supposed to be some sort of emergency broadcast test on our phones and all that good stuff. So I think that's supposed to be on the 11th, but we'll see. So I don't know what's per se what is actually coming, but something needs to happen here. So, and I know things are heating up with the thing that seems to be having a hard time being proved. And I think it was Ireland. Ireland, I think, was the other one that just recently did a demand to prove the thing exists. So Canada and Ireland, I think we need to do something about it here, except for, there is that one out of California, virologist down there who demanded the CDC proof, and they didn't have it there either. So no, they don't have proof. They don't have proof this sucker exists. Oh, whoa, my bad. EF, right? The big fraud. The thing that doesn't exist was a cover up for the fraud, so they could try and get away with it. So funny, both of them are fraud, huh? What a scheme, scam, and a fraud. But we're we're in the day and age where media is controlled, exactly what gets to be told out there, and the fear. Fear mongering, of course, right? Trying to get us all stirred up, so we'll have fighting amongst ourselves. Yep. And that's exactly what we're talking about. Yep. And there's that little symposium thing. From the the My Pillow guy. He has a little bit of something to share with a bunch of people. Right? Cover up, cover up, cover up. And of course, then the thing is if we can't prove that this thing exists to begin with, how could there be any kind of a new variant of something that doesn't exist. I mean, it's like, if it doesn't exist to begin with, how can there be a new strain, a new variant? It just, ow, kind of hurts my brain here. Why? How's that logically possible? You mean a new strain of BS? Because I don't know, the truth's starting to come out about the EF, the fraud. Got to try and cover that up. Oh, so stay calm, go out, exercise your rights, and that's this thing seems to be on the uptick again about masks and that stuff. So you know what? Do what you can to get by, and just again, Bible talks about my people shall perish for lack of knowledge. At this particular point in time, it's too late for a lot of people to wake up. If you're not woke up by now, probably not going to wake up. And for some, clearly it's too late. You think you need to put something in your body to protect you from something that doesn't exist, that you didn't take the time to do your own research and just blindly followed without asking questions. I'm sorry, but you made that choice. Ignorance of the law is no excuse. Ignorance, period, is no excuse. Especially in today's day and age where we have the internet, the information highway. There's literally pretty much nothing out there that you can't research and study for yourself, not having to go to school, that you can study on the internet. I mean, there's a plethora of information out there on whatever subject your heart desires to research and find. And I mean, I'm not sure how many people have did a search for something and didn't find any information. So maybe somebody can post that. You actually did a search for some on a certain subject and you couldn't find any information on it out there on the internet in 2020, 2021 here. Hi, Carol. Good to see you. Right? Carried away by the glitter. Or wait, yep. Well, so I know that I haven't really done a whole lot covering like family law stuff in a while. So I've had a couple people over the last few months ask about Hardwick versus Rican, that kind of stuff. So I've got Hardwick versus Rican here pulled up. And we're gonna do a read through on that, and I'm gonna share my little lawful notification letter that I put together a couple years ago for parental rights. So this just letter. Dear John Doe, I, Kirk Pendergrass, being one of the people of the Idaho, do hereby put you on notice of the following trespass of the law. My right to the decision making was good or not good for my child is my decision alone. Government policy that comes in conflict with my right is void for any effect. Servants in government do not have the authority to alter the fundamental law or the Constitution, more specifically, my rights retained by the people. You are in violation of the following amendments of the Bill of Rights, 1791, first, fourth, fifth, seventh, or sixth, seventh, ninth, and 10th. You're in violation of the following sections of Article 1 of the Constitution of the State of Idaho, Declaration of Rights, 1, 4, 7, 8, 13, 17, and 21. You're in violation both of state and federal law, conspiring to deprive rights retained by the people. That's 18 U.S.C. 241. Deprivation of rights retained by the people by action under color of law, i.e. a statute, a policy, a regulation, or a rule. That's 242. Embezzlement, by using your position of employment as an advantage to commit the foregoing crimes while receiving a profit or gain. That's emoluments violations, 18 U.S.C. 643. Be advised, you are to cease and desist any further action. Any action taken by you or any other part of your agency will be deemed as a trespass of the law after notice. You will be subject to a tort of 250,000 United States dollars per agent per violation and 500,000 United States dollars per agency per violation, 18 U.S.C. 3571. And a remonstrance pursuant to Article 1, Section 2 and 10 of the Declaration of Rights of the Constitution of the State of Idaho. Now, again, this is this particular part here is back before I knew the difference between a petition and a remonstrance. This would be a petition pursuant to Article 1, Section 2 and 10. Notice to agent, notice principal, notice principals, notice agent. This notice requires your immediate written response. This is just a quick, hey, here's my rights that you're trespassing on. You have no lawful authority. Done here. Cease and desist all your actions against me, whatever it is. Okay, this is just a simple lawful notification letter, putting them on notice. Now, this is the Hardwick versus Vreeken case, okay? Summary, this was, and just so everybody knows about this particular case, it took 17 years for them to say, oh yeah, social workers can't lie. I could have swore the 9th commandment says thou shalt not bear false witness. That's supposed to be common sense. So the panel affirmed the district court's denial on summary judgment of absolute and qualified immunity to social workers. Oh, I suppose I better fix this. Oh, that's probably all right anyways. Okay. District court denial on summary judgment of absolute and qualified immunity to social workers who plaintiff alleged maliciously used perjured testimony and fabricated evidence to secure plaintiff's removal from her mother, and that this abuse of state power violated her 4th and 14th Amendment constitutional rights to her familial relationship with her mother. Okay. So many people out there I'm aware of has been subjected to this crap, and including myself, clear back in 1985. I was the child that was taken by social workers of the state of Washington. And not given back to my mom. So, whoops. The panel held that the social workers were not entitled to absolute immunity from claims that they maliciously used perjured testimony and fabricated evidence to secure plaintiff's removal. The panel held that plaintiff's complaint targeted conduct well outside of the social workers' legitimate role as quasi-prosecutorial advocates in presenting the case. The panel held that defendants' case for qualified immunity was not supported by the law or the record. The panel determined that the plaintiff produced more than sufficient admissible evidence to create a genuine dispute as to whoever her removal from her mother's custody violated her constitutional rights. Now, here's the thing. This is the daughter. This was the daughter that brought the suit. The panel further stated that it could not conceive of circumstances in which social workers would not know and understand that they could not use criminal behavior in any court setting to interfere with a person's fundamental constitutional liberty interest. Okay, wouldn't that just apply to everything? Fundamentally and principally, yes. You can't use fraud, criminal behavior in any court setting to interfere with a fundamental constitutional liberty interest, except for they're not constitutional. These are God-given rights. These are unalienable. They are among our aggregate of guaranteed rights. They are our property. They are outside of the sphere of governmental control. None of their business. No subject matter jurisdiction, no personal jurisdiction. But we all know what they've been into. Human trafficking, both part A and B. Oh, this summary constitutes no part of the opinion of the court. Really? No part of the opinion at all. Okay. But when we read the opinion, it sure is in there. This was County of Orange County, California, or Court of Orange County, California. Let's see. The individual defense unsuccessfully raised absolute and qualified immunities as shields against this action. They appealed, claiming, among other things, that the law Presley accuses them of violating was not clearly established at the time their allegedly wrongful conduct occurred. Clearly established. Thou shalt not bear false witness. What about perjury? Perjury is not clearly established. Pursuant to the statutes of fraud and perjury. Long time ago. We have jurisdiction over this timely interlocutory appeal pursuant to absolute immunity and qualified immunity. Right. This lawsuit is not the first stemming from the implosion of Presley's family. Her mother, Deanna, successfully sued some of the social workers in state court for the same conduct and pursuant to the same legal theory, and she recovered a sizable sum in damages plus attorney fees. So there's other ones. Fogarty Hardwick versus County of Orange. There's another case. Remanded to trial court with directions to strike injunctive relief from the judgment and affirming judgment in all other respects to the quote California Court of Appeal. In this case, the jury specifically concluded that Vreekan and Dwojak lied, falsified evidence, and suppressed exculpatory evidence, all of which was material to the dependency court's decision to deprive Fogarty Hardwick of custody, and that they did so with malice. Now, here's a little bit to comprehend here. This is mens rea. Knowingly willingly, with malice is mens rea. It's one of the part of the element of a crime. The mind is guilty. That's what mens rea means. So for those of you on the criminal side of things, demand proof of mens rea. But that would be denial of exculpatory evidence. Where's the evidence to support the claim that you have the evidence to support the claim that I knowingly, willfully, with malice, intended to cause this injury, loss, or harm? Well, in this particular case, we can clearly see that they did because they lied. That's knowingly, willingly, and with malice because, well, we get to do whatever we want to do and we get money for it. These findings are clearly sufficient to satisfy the Supreme Court's definition of circumstances in which qualified immunity would not be available. The Court of Appeal also acknowledged the defendant's collective admission on appeal that the evidence was sufficient to demonstrate the social workers committed egregious acts of misconduct in the dependency case. The court said, as the county concedes, Hardwick demonstrated, if the testimony is to be believed, that in this one instance, social workers lied and fabricated evidence in connection with the dependency proceedings relating to her children. So here's the scope and standard of review. This matter comes to us as an interlocutory appeal involving only legal issues regarding the employee's claims of an entitlement to immunity from the lawsuit. We do not comment on or express any opinions about the merits of the case. Those are ultimately for district court to resolve. In this context, however, and because they are supported by the record as a whole, we construe the facts Presley offers in support of her allegations in the light most favorable to her. Accordingly, we proceed to review de novo the legal issues that are before us. De novo is do it over again. Absolute immunity from private lawsuit covers the official activities of social workers only when they perform quasi-prosecutorial or quasi-judicial functions in juvenile dependency court. The factor that determines whether absolute immunity covers a social worker's activity or function under scrutiny is whether it was investigative or administrative, on one hand, or part and partial of presenting the state's case as a generic advocate on the other. Absolute immunity is available only if the function falls into the latter category. Here, Presley tells us that the social worker's malicious activities about which she complains are as follows. Let's see. The allegedly false statements and omissions made in defendants' court reports continuously submitted by them from February 17 through the termination of the dependency proceedings. The statements made by the defendant social workers during an off-the-record discussion on February 17, 2000, and during an on-the-record discussion that same day, where the social workers allegedly lied, but not while under oath, to the commissioner overseeing the dependency proceeding, triggering Presley's seizure. The alleged fabrication of the evidence throughout the dependency proceedings and repeated suppression of exculpatory evidence in defendants' written court reports and defendants' corrupt recommendations that Presley continued to be detained even though defendants allegedly knew they were lying to the court about the basis for the initial seizure and subsequent detention. To be specific, the defendant's actions Presley intends to prove a false and fabricated include one, telling the dependency court on February 7, 2021 that Deanna had caused her daughters to skip a mandatory visit with their father, when in fact the problem was caused by a visitation monitor, Hector, advising the court that Deanna was responsible for turning her children against the monitor, and 3, telling the court that Deanna had told her children that her father was trying to take them away from her, when in reality it was defendant Vreeken who had made inappropriate comments to the children, including the threat that if they did not visit their father, they would be put in a home. The basis of this alleged misinformation, the dependency court concluded that Deanna was using her children. Accordingly, the court immediately removed the girls from her custody and turned them over to the SSA and the defendants. Presley and her sister were sent to the Orangewood Children's Home on February 23rd, 2000. The court authorized the return of the girls to their mother's custody, but the social workers refused and placed them instead in foster care, where they remained until May of 2000. So here's the thing right there. The court authorized the return of the girls to the mother's custody, but the social workers refused. Excuse me? You see the mentality of these social workers here? Kind of just seems to be a little bit of a pattern of behavior within government. You know, these people do whatever the heck they want to do, and this is the game they play. And do whatever you want to do, and catch me if you can. Yeah, exactly. I got to experience this stuff myself firsthand at just before I turned 14. They lie, and I'll tell you, that social worker in my case said, "Oh, well, if your mother loved you, you'd already be back home by now." But look at this right here. The court said to return the children to the mother, but the social workers refused and placed them instead in foster care, where they remained until May of 2000. That's it right there. These people just do whatever the heck they want to do. But you have to know how to deal with this. And I say, you, as the man or woman, don't hire a member of the bar. They're to design. They're designed to play the game. And then here we are. It's like in 2017, going, wait a minute. But there's no law that says we can't lie. Really? Presley's complaint targets conduct well outside of the social worker's legitimate role as a quasi-prosecutorial advocates in presenting the case. Our opinion in Beltran disposes of this issue. We held in Beltran that social workers may well have absolute immunity when discharging functions that are critical to the judicial process itself, but they are not entitled to absolute immunity from claims that they fabricated evidence during an investigation or made false statements in a dependency petition affidavit that they signed under penalty of perjury, because such actions aren't similar to discretionary decisions about whether to prosecute. Accordingly, we affirm the district court's denial of these defendants of absolute immunity. Immunity revoked. It's called ultra vires. So here's a collateral estoppel. Priscilla claims collateral estoppel or issue preclusion against these defendants on the ground that qualified immunity was conclusively litigated to a final decision in California courts, in which they did not prevail. However, because we come to the same conclusion as the state courts, we need not decide whether offensive collateral estoppel bars these defendants from raising qualified immunity in their defense. Parents and children have a well-elaborated constitutional right to live together without governmental interference. What's that I put in here? My right to the decision making is what is good, right? Or not good for my child is my decision alone. Government policy that comes in conflict with my right is void for any effect. Servants in government do not have the authority to alter the fundamental law of the Constitution, more specifically, my rights retained by the people. It's my right to the decision making, not government. That right is an essential liberty interest protected by the 14th Amendment's guarantee that parents and children will not be separated by the state without due process of law except in an emergency. But you have to, we'll get down later, you have to prove the emergency, and it has to be life or death, immediate threat to life or death. And the fact is, it's not the 14th Amendment. Because this is a natural right. But that's okay. Fourth, fifth, and sixth article of the Bill of Rights over the years, the Supreme Court has recognized this fundamental right in many cases. Oh, wait, fundamental rights don't come from the 14th Amendment. By the way, they're long antecedent to the formation of government. So, well, what do we need the 14th Amendment for? It's what the 10th Amendment or Article 10 is that there are other, ninth, that there are other rights retained by the people that are not enumerated here. So, over the years, Supreme Court has recognized this fundamental right in many cases. For example, in Cleveland Board of Education, the court said, this court has long recognized that freedom of personal choice in matters of marriage and family life is one of the liberties protected by the Due Process Clause of the 14th Amendment. How about the Fifth Amendment? The Fifth Amendment says due process of law. Sixth Amendment, Fourth, Fifth, and Sixth are the three main due process of law articles in the Bill of Rights. Not the 14th. I mean, if it's deeply rooted in our nation's history, didn't that come before the 14th Amendment? Yeah, sure did. The court reiterated this theme 3 years later. Our decisions established that the Constitution protects the sanctity of the family precisely because the institution of the family is deeply rooted in this nation's history and tradition. It is through the family that we inoculate, okay, whatever that one is, okay, and pass down many of our most cherished values, moral, and cultural. The defendants do not contend, nor could they, that Presley did not have a constitutional due process right or a Fourth Amendment right protecting her against deliberate government use of perjured testimony and fabricated evidence in the dependency court proceeding designed to rupture her familial relationship with the mother. This right is beyond debate. What they do claim is that the specific granular right to be free from deliberately fabricated evidence in civil child dependency proceedings, where a parent's or child's protected familial liberty interest is at stake, had not yet been clearly established. Really, prior to the dependency proceeding at the issue, they concede that the rights of Presley relies upon had been clearly established in criminal proceedings against parents, but not yet in a civil proceeding context. We disagree. Of course they disagree. Because thou shalt not bear false witness. It's deeply rooted in our nation's history. You cannot lie, period. That's why you have to sign this crap under penalty of perjury. Clearly established, an official cannot be said to have violated a clearly established right unless the right's contours were sufficiently definite that any reasonable official in his or her shoes would have understood that he or she was violating it. Oh man. This exacting standard gives government officials breathing room to make reasonable but mistaken judgments by protecting all but the plainly incompetent or those who knowingly violate the law. Let's see. This is not to say that an official action is protected by qualified immunity unless the very action in question has previously been held unlawful. But it is to say that in the light of pre-existing law, the unlawfulness must be apparent. Furthermore, general statements of the law are not inherently incapable of giving fair and clear warning, and in some instances, a general constitutional rule already identified in the decisional law may apply with obvious clarity to the specific conduct in question, even though the very action in question has not previously been held unlawful. Okay, has it ever been previously held unlawful that you can't lie? Thus, the salient question we must answer is whether the state of the law, as if ever when the conduct at issue allegedly occurred, gave these social workers fair warning that their alleged use of perjured testimony and fabricated evidence in court in order to sever Presley's familial bond with her mother was unconstitutional. Wow. In 2000, February of 2000, we don't know the 9th commandment that thou shalt not bear false witness. Did you go to grade school? I mean, they kind of taught that in grade school, even, that you're not supposed to lie. The Supreme Court did not confine its inquiry in hope to published judicial opinions. The court also referred to the obvious cruelty inherent in the disputed practice that should have provided respondents with some notice that their alleged conduct violated the plaintiff's constitutional protections. So here's another thing, what we're looking at here. Talking about, oh, well, we didn't know. Lawful notification letter. Put them on notice. Can't claim they didn't know if you put them on notice. Because you can always prove that you served them with a lawful notification letter. To buttress its conclusion that a reasonable person would have known of the unconstitutionality of the disputed practice. The court also relied on a relevant shackling regulation promulgated by the Alabama Department of Corrections, and 2, a United States Department of Justice report warning the ADOC, the Alabama Department of Corrections, of the unconstitutionality of the disputed practice. Although it did not, so this is, I guess, development section here. Although it did so in the context of discussing collateral estoppel, the district court correctly identified the legal precedents that inform our analysis, beginning with Green, vacated in part on other grounds. As the district court said, the plaintiff in Green alleged her children were removed from her custody pursuant to a juvenile court order triggered by an intentional misrepresentation in an affidavit by the defendant social worker. Now, here's the thing. Again, why are we going through juvenile proceedings for something that's supposed to be set up for juveniles when the juvenile isn't the criminal or the alleged criminal here. This makes no logical sense. At least it doesn't make any logical sense to me that if it's not the juvenile, the one that's being accused of some sort of crime, how in the heck is this even being heard in a juvenile court? When the juvenile isn't even the one that's supposed to be on trial. If it's the adult that's on trial, how in the hell is that being done in a juvenile court? They're not a juvenile. And then if you're talking about something that's criminal in nature, why isn't this happening in a criminal court? Things that make you go, So here we go. In an affidavit by the defendant, social worker. That's why you have to rebut them. The Ninth Circuit held that the plaintiff's right to be free from deception in the presentation of evidence during a protective custody proceeding was clearly established at the time defendant filed his affidavit in 2003 with the juvenile court. And as the district court correctly observed, Green reached this conclusion on the basis of previous case law establishing the basic constitutional right to be free from the knowing presentation of false or perjured evidence. Wow. In 2003, you're relying on that one. I think the Ninth Commandment's been out there for a long time. Nevertheless, the defendants contended that Green is irrelevant because the offending affidavit in the case was filed on March of 2003. And 2, we did not publish our opinion until 2009. True, but Green relied in turn on cases dealing with conduct that occurred well before the conduct challenged in this case. Again, why are we talking about cases? I could give a rat's ass about what the judicial branch's opinion is on what our frickin' rights are. Our rights are actually the law. Stare decisis. I hate to be the bearer of bad news here, but in our form of government, the judicial branch doesn't have the power to make law. It's a monarchy. We're not a monarchy. We're a republic. We're not a democracy either. We're a republic. So, again, our rights come from God. Those endowed by our Creator with certain unalienable rights. Among these rights are life. My son or daughter is my life. While they may call it a fundamental liberty interest, what they're talking about there's the decision making and that kind of stuff. But that's my lifeblood, my DNA. Liberty is about choice and actions. Life is about, creating life. That's my lifeblood. My son is part of my life, not liberty. Targeted content took place during 1994. In Green, we said that we held in the context of a child abuse proceeding that the constitutional right to be free from the knowing presentation of false or perjured evidence is clearly established in 1994, 95. Oh, but this was civil. This is, well, it's not even civil. This is a shit made up court. We also said that even earlier, was stated emphatically that if an officer submitted an affidavit that contained statements he knew to be false or would have known were false, had he not recklessly disregarded the truth, he cannot be said to have acted in an objectively reasonable manner, and the shield of qualified immunity is lost. Yeah, ultra vires. Finally, we supported our holding in green with the Section 1983 case as in 1990, the 10th Circuit. We described that civil rights cases holding that social workers who deliberately fabricated evidence of child sexual abuse to secure a removal order were not entitled to qualified immunity. Again, there we go. BS. I just don't get it. How is it that we can even begin to sit here and think that, man, I don't know, that it's okay to lie? But this gets good down here later. Contrary to the defendant's assertion at oral argument that Snell arose from criminal process, it did not. The alleged offending social workers in Snell were employed by the Oklahoma Department of Human Services. The disputed court order they secured from a judge was a pickup removal order pertaining only to civil child dependency concerns. The child removal order had no connection with the criminal investigation or prosecution. Well, why? Why not? You're trying to deprive a fundamental right. Can't be done civilly. Got to be done through criminal. The child removal order had no connection with the criminal investigation or prosecution. Well, then how are you going to go in there and make an arrest? Doesn't make any sense to me. In fact, the district attorney, the local police, and the FBI all declined to initiate criminal process or proceedings. Okay, here you go. No official with an IQ greater than room temperature in Alaska could claim that he or she did not know that the conduct of the center of this case violated both state and federal law. The social workers in this case are alleged to have knowingly and maliciously violated the law in their attempt to sever Presley's protected relationship with her mother. Perjury is a crime under both federal and California state law, as is the knowing submission of false evidence to a court, 18 U.S.C. 1621. That's the perjury. 1622 is subordination of perjury, which is the negative nexus that Chris taught us. -1 times a -1 equals a +1. The first perjury statement's the -1. The second one is would be the prosecutor or whatever bringing this before the court, and the court sees this as a +1, as the truth. But they're lying. Both crimes make no distinction between criminal and civil proceedings. That's right, folks. Perjury is a felony. Thou shalt not bear false witness. It doesn't matter if it's in a criminal proceeding or a civil proceeding. Perjury is still perjury. You got an IQ greater than room temperature in Alaska or not? Starting to believe some of these people really just do not have an IQ that high. Where are you at, Cece? What's the temperature in Alaska right now? All right, let's see. Both crimes make no distinction between criminal and civil proceedings. This malicious criminal behavior is hardly conduct for which qualified immunity is either justified or appropriate. The doctrine exists to protect mistaken but reasonable decisions, not purposeful criminal conduct. That's right. They have immunity, not from criminal conduct, which is perjury. As the Supreme Court repeated in Sheehan, officials who knowingly violate the law are not entitled to immunity. knowingly violate the law. Well, of course, ignorance of the law is no excuse. We all know that, right? To know a thing and to be bound to know it or regard it in law as equivalent. There's two maxims of law right there. But lawful notification letter, putting them on notice. They can't deny the fact that they didn't know. Okay. Hardwick versus Freakin, County of Orange. Fifteen 55563. DC number, blah, 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 blah. There you have it. This is over in the Ninth Circuit over here, West Coast. This is where you file criminal complaints against them because perjury is a felony. Here in Idaho, it's 1 to 14 years prison time per count. So let's see, where are we at here? Have to know your rights, folks. You got to perform your administrative duties in the very beginning of a case. You know, I know it's hard when you're right in the middle of it going, oh crap. What do I do? What do I do? I know, been there myself, which is part of the reason why I decided to start studying law back in 1995, 26, almost 27 years ago. And I just delusional, mindless drone people out there. Well, how could you possibly know anything about the law without going to law school? Really? No clue. There's no possible way. Nobody ever can know anything about the law without going to law school. But yet, ignorance of the law is no excuse. And to know a thing and to be bound to know it or regarding law is equivalent. And the Declaration of Independence talks about our rights are supposed to be self-evident. Common sense. Kind of weird. I mean, man, these people are just freaking nutsos, insane. Right? Reading means reading. Yeah, I know. Jacqueline, I hear lawyers are constantly telling me you're wasting your time. Yeah, wasting your time trying to go to law school because they don't even teach you the law in law school. They teach all this case law crap. So I just recently found out they don't even teach law. Period. Real law, LAW, not code and not case law. That's not law. I don't know. Them lawyer members of the bar out there probably, they don't, they want to keep their money revenue, the confidence man, the confidence game, and the confidence trickery. It's a scheme, scam, and fraud of the bar. I mean, I don't know how many times I've sat in on court cases and including my own, waiting for mine to be heard, and hearing members of the bar up there stumbling all over themselves and have no freaking clue what the hell they're doing. It's like, this guy went to law school? Well, now I'm getting a little bit more of inside information about what they actually teach in law school. It ain't what you think. They sure in the heck don't teach law in law school. So, just saying. No, not confidence law, confidence man, confidence game, confidence trickery. Yep. Original article the 13th. Remember, according to the Bill of Rights, the real Bill of Rights. Oh, what does that say? Articles in addition to an amendment, not amendments. Of the Constitution of the United States of America. Article the 1st, Article the 2nd, Article the 3rd, Article the 4th, Article the 5th, Article the 6th, Article the 7th. These are articles in addition to an amendment. The whole Bill of Rights is the amendment because the Constitution has articles. And in contract law, according to some basic contract law stuff, these are articles. But see, all of that was subverted in 1871. I've showed it before. It was original Article the 13th was published even in our first legislative session in the territory of Idaho in 1863. It's published in there. Not Article 13th, but it does say it stops at 12. Imagine that. So, I know we got a late start, but it's been a long week. I tell you, folks, a lot of things going on at the office, a lot of things going on with what we have going on, what I have going on. I'm pretty much run down for the week. So I'm going to call it a night. I want to thank everybody for being here on a Friday night, having some fun here. So hopefully that puts a little bit out there for your family law people. I know I haven't done a whole lot on the family law stuff in quite a while, but it's the same old out there in the family law realm of things. Actual no movement, nobody learning anything, nobody doing anything, nothing has changed. It's the same old, same old. All right. So just want to thank everybody for being here, trying to learn, trying to get educated, having a little bit of hangout time on tonight, right? So again, thanks to the team, the new team developing right now. Everybody behind the scenes here make all this stuff happen. Thank you all for being here and hanging out. All right. So if you'd like to help support the channels and help keep this stuff going here, 6477 West Fairview Avenue, Suite C, Boise, Idaho 83704. For those postal money orders, regular money orders, cashier's checks, regular checks, cash wrap, aluminum foil, gold, silver coinage, anything like that. No digital side of things as of yet. Patreon. Patreon.com/Kirk's Law Corner, of course. If you're not on Patreon yet and you want to get in there for the Wednesday night workshop, we're really having some pretty good discussions and stuff in there. So ask the people that have been in there. Some of them are on here right now. It's some really good stuff. And then the other thing is that that's tier, by the way, that's tier 3 for tier 3 and tier 4 people. And then kirkslawcorner.com. You might want to get your email on there. And for those of you that have given the email, if you'll notice you've never received an email yet, that's because I'm not going to spam you. I'm not there to, this is supposed to be a backup plan in case things go down here on Facebook or YouTube. So you would know I can get a hold of everybody, let you all know where I've gone to, just in case, right? So maybe when we get things up and going, we'll set out like a little newsletter or something like that once a month or something. But I don't want to spam everybody. I know some people out there, you give them your email and it's like spam the crap out of you. I'm not one of those kind of guys. So with that being said, much love, everybody. Thank you all for being here. Thanks for the likes, the follows, the shares. And I know apparently there's been some issues with sharing on YouTube. So I'm not sure what's going on there, why there's no share option for some people, other than it's marked as not made for kids, but didn't have much of a problem before. This is something that's come up recently within the last couple of months. So yeah. So much love, everybody. Everybody hopefully you all have a wonderful weekend, and we'll see you back here for Monday Night Law. All right. All right. Have a good night. We'll see everybody Monday Night Law. Good night, everybody.